Hello, everyone, and welcome to today's webinar presentation, Court to Courtroom, Mastering Workplace Investigations. As the excitement of March Madness sweeps the nation, it's time to bring that same energy and strategy to your workplace investigations. Just like a championship team, conducting thorough and impartial investigations is crucial to staying ahead in today's litigious environment. But before we get further into today's topic and awesome basketball analogies, I would like to take a moment to introduce myself and my organization. My name is Zielinski, and I'm the Marketing Director for ComplianceHR. You may recognize my name from the email invitations that you received for today's event. To prevent a few popular questions from entering the Q&A box, I'd like to let you all know that this presentation is recorded and will be emailed to you. So please keep an eye on your inbox for an email from ComplianceHR webinar. Our goal at ComplianceHR is to simplify the complexity of employment law, making sure your compliance strategy is a slam dunk. To achieve that goal, we offer a suite of technology solutions around critical HR compliance topics, like employee overtime, independent contractor classification, employee handbooks, onboarding, leave, and many others. Today, I would like to briefly introduce you to two of our most popular solutions, PolicySmart and the Reference Center. PolicySmart is a comprehensive handbook solution that provides you with federal and state compliant templates, a compliance policy timeline, handbook checklists, and automated emails to alert you on new legal changes going into effect. The Reference Center is a solution created to help you and your team quickly answer employment law and HR compliance questions. With information on a wide range of compliance topics, deep insights that bridge multiple compliance concerns, and even side-by-side reports that compare information across jurisdictions, the Reference Center aims to help HR and legal professionals do their jobs more efficiently and effectively. Avoid unnecessary fouls, like potential lawsuits, reputational damages, and disgruntled employees. An up-to-date and legally compliant employee handbook helps to hold your employees accountable for knowing your organization's culture, standards of conduct, and compliance policies, helping to simplify the workplace investigation process. Make sure your team has access to the right HR compliance playbook with PolicySmart in the Reference Center by signing up for a demo of these solutions today. If you're interested in learning more, a survey should have popped up on your screen, though you may have to exit full screen mode to see it. If you'd like to sign up for a demo, simply answer yes, and I will send your contact information to our team of experts to have a deeper conversation with you about your compliance strategy and how ComplianceHR can support it. In addition to a demo of our solutions, you may be eligible to receive a free trial so that you can see precisely how much time and money they will save you. If you're not sure at this time, I'll send the poll out once more before we conclude the presentation. You can always visit our website or request more information in the Q&A box. Now, I have the pleasure of introducing today's webinar presenters, Natalie Storch, Robertson, and Mikayla Almeida, with backgrounds across a broad range of employment law-related matters, including wage and hour law, employee relations, and discrimination, harassment, and retaliation claims. Natalie, Lauren, and Mikayla are experts on today's topic. So presenters, take it away.
Good afternoon, everyone. We are thrilled to have you with us. This is Natalie Storch. I'm a shareholder in the Orlando office. I'm joined by Lauren and Mikayla, also in Orlando office. And I wanted to just, for housekeeping purposes, let you know you're welcome to type questions in the chat during the presentation. We will wait till the end to answer any questions verbally, but we can respond to some during the presentation if we have a chance. We're thrilled that you're here with us. And to tip things off, let me tell you a little bit about what we're going to be covering today. We hope that this information is helpful to you in mastering workplace investigations, court to courtroom. Hopefully you don't get to the courtroom because your investigations are so robust. But today we're going to be talking about why we investigate, why we are talking about investigations and procedures to make them the best investigations possible, how we plan investigations, tips for conducting investigations and best practices, and avoiding common investigation mistakes. You're probably asking yourself, or maybe not, why do workplace investigations matter? They are critical. They're a critical tool for addressing employee concerns, ensuring compliance, and mitigating risks. First, excellent investigations can help avoid lawsuits. Conducting prompt and thorough investigations demonstrates the employer's commitment to addressing complaints, reducing the likelihood of litigation. Proper documentation serves as evidence that the employer exercised reasonable care to prevent and address misconduct, discrimination, or harassment. And we're going to talk a little bit about consulting legal counsel during the investigation, which ensures compliance with applicable laws and helps preserve attorney-client privilege. Another reason investigations are important is they provide defenses if there is a lawsuit. They help employers gather facts and evidence, much like a coach reviews game footage to prepare a defense strategy. This evidence gathered during these initial investigations can be used to defend against claims of negligent supervision, retention, or training. Gathering documents, information, photographs, preserved other material, and preserving evidence are critical tools for opposing later changes in testimony or allegations. Following standardized investigation guidelines ensures consistency and fairness and strengthens the employer's position in any legal dispute. Another important aspect of why investigations matter is managing reputational damages. Addressing issues proactively is akin to a team managing its public image during a high-stakes sports tournament. Prompt and effective investigations signal to employees and the public that the organization takes complaints seriously and upholds its values. Confidentiality is important during investigations to minimize the risk of publicizing sensitive information that could damage the organization's reputation. Well-handled investigations can prevent negative publicity and demonstrate the organization's commitment to integrity. Another reason investigations matter is it can address employee morale issues. Team spirit is essential during a big game. Similarly, employee morale improves when concerns are promptly addressed and policies against misconduct are enforced. Reiterating anti-retaliation provisions during investigations reassures employees they can report issues without fear of reprisal. Another critical aspect of conducting investigations properly are addressing compliance violations. Investigations help identify and address potential violations of workplace policy, regulatory requirements, or laws, much like a team reviews its playbook to ensure compliance with game rules. Employers can use findings from investigations to implement compliance enhancements and prevent future violations. Just as success in March Madness requires preparation, strategy, and teamwork, successful workplace investigations require careful planning, adherence to policies, and collaboration among HR, legal counsel, and management. We hope you enjoyed today. I'm going to turn it over to Lauren to talk about common challenges companies face in workplace investigations.
Thanks, Natalie. So we're going to be talking about those common challenges in the context of March Madness style. I'm not sure who you have winning your March Madness bracket, but go Gators. The first up is pre-game jitters. What do I mean by that? I mean, investigators can feel unsure or overwhelmed before diving into a case. Maybe it's the breadth of the investigation. Maybe it's the investigator's first time that they're investigating a matter, or maybe it's high stakes. Either way, preparation and confidence is key in your process to preparing for any investigation and dispelling and getting past those game day butterflies. Fickle fans, I mean, we all know how fast fans can turn on a team. 1 minute, they're cheering you on. The next minute, they're calling for your job. In investigations, that's bias creeping in, whether it's coworkers pushing a narrative or leadership expecting a certain outcome. You as the investigator have got to keep your head in the game and stick to the facts. Don't let the crowd influence your calls either. Then there's the myth that you need a formal complaint, a formal written complaint from an employee to launch an investigation. And that's just simply not true. In our world and in the employment context, it is all about notice. And if someone drops a hint of misconduct, even if it's just during a coffee break or at the water cooler in the morning, you're officially on the court and it's time to grab the ball and start the investigation process. One of the common pitfalls that we see as external counsel is that companies just aren't implementing the right training for their managers. So investigations become delayed because timely reports of concerns raised to managers just in an informal setting are not ever transposed or given to the investigations team. And then let's talk about shot clocks. So at this point, you've received a report or a complaint. I mean, you don't have forever to investigate those allegations. The longer an investigation drags on, there's concerns that come with that, such as a higher risk of losing evidence, fading memories, and frustrated employees. So you as the investigator have to really find the balance between thoroughness with efficiency. Take the shot before the buzzer sounds. And finally, confidentiality challenges. This really is a big one. So think about your investigation as your team's game strategy. If it gets leaked, it could tank your whole case and effort. So gossip and side conversations, or this is just between us, chats can really seriously damage the credibility of the company, your role and integrity as an investigator, and the trust. So as we kick off this training, think of yourself as the head coach, calling the right play under pressure. So I'm going to turn it over to Mikayla to kick us off on how to build a strong investigation plan.
Thanks, Lauren. Let's start by meeting our players. So the investigators are going to act as the head coach. And just like a head coach leads the strategy in the investigation context, investigators are going to determine the best way to go about the investigation while staying within the rules. The complainant, the person lodging the complaint, is going to be similar to your point guard. In basketball, of course, when your point guard is leading the offense, and so in our context, the complainant is the one lodging the complaint, and the complaint will ultimately help the investigator decide what play calls to make to thoroughly investigate the allegations. We also have the accused. So on defense, of course, an opposing player is going to try to be blocking the point guard's shots. This is the accused, who is usually on the defensive, trying to refute or defend against the complainant's allegations. We also have the other players on the team, our shooting guards, our power forwards. They're playing an important role that can impact the outcome of the game too. These other players are the witnesses who may help the investigator ultimately determine whether the complainant's claims are substantiated or unsubstantiated. Finally, that brings us to HR and legal. As we know, referees are there to make sure the predetermined rules of the game are being followed. And in the investigation context, the company's HR and/or legal department is there to help ensure fairness and adherence to the established rules, procedures, or laws. So now that we've met the players, let's look at an overview of the key stages of the investigation process. Simple, right? The illustration here highlights the complicated nature of the investigative process. After you receive the complaint and interview the complainant, if they provide documents, you might need to conduct re-interviews, you might need to re-interview other witnesses, but generally you can see the overarching process consists of receiving a complaint, interviewing the complainant, interviewing the witness and the accused, and reviewing documents that may be submitted. If there are additional interviews that need to be conducted, you can do that at that point. After you review all of this data, then you're going to reach a decision, document it, implement that decision, and organize the file to make sure it's adequately maintained and preserved, again, for hopefully it won't get to litigation, but in the event it does. And then, of course, we're going to follow up. So let's go ahead and start at the beginning. Natalie, can you tell us what HR received this weekend?
Yes. While HR was busy watching basketball, an employee was busy leaving a voicemail on the hotline. And this is what the voicemail said. Hi, I'm going to keep the name confidential. I'm a long-term employee and I've had enough. My working environment in customer service has become unbearable and I'm being treated unjustly. Look, being passed over for a promotion in favor of a racist, well, that just can't be overlooked. Now I understand why some employees can give perks to some clients, but some clients aren't worth it. Anyway, I'm not sure how this hotline works, but hopefully something can be done. So not a great way to start your Monday morning as an HR professional, but with an investigator's eye, assess in this scenario whether there are issues presented that merit an investigative follow-up. Lauren, I know we've given you some initial tips so far, and you probably have an idea of how you typically conduct an investigation, but sometimes that can be overwhelming.
So Lauren, can you kind of start by talking to our wonderful audience about where you begin?
Yes, Natalie. So before we jump into action, we have to define the purpose of the investigation and set some ground rules. So what is this investigation going to cover? Because that truly is your starting point. You have to look at the allegations of the complaint, the specific conduct being alleged. Is it a policy violation? If so, what policy is the conduct being alleged in the complaint violating? I think this is the most critical point for you as investigators to remember as far as identifying the policies, procedures, and standards at play. You really have to think of this as reviewing the NCAA handbook before tip-off. Because if you don't know what policy you're investigating, or in terms of the allegations and whether that meets a violation, then you're not going to be able to come to a conclusion, because the rules really do determine the calls that you make. So if you have no rule book, you have no game. Lastly, you also want to set your objectives and boundaries of your investigation. So are you fact-finding, which you are typically in most investigations? If so, what evidence do you need to review? What witnesses do you need to speak to? But not only witnesses, what objective documentary evidence would be able to help you with respect to understanding and investigating the allegations. So you really have to keep your eyes on the ball, follow the playbook, and don't let your investigation really turn into a full court scramble. And what I mean by that is when someone drops a new allegation mid-investigation, something completely and totally unrelated to your current scope, what do you do in that context? Well, you don't ignore it, but you also don't chase it down in the moment if it's completely unrelated. There are times when, especially when the allegations or the new issue that comes up is related to the current complaint that you're investigating, that you will go down that rabbit hole and follow up with the requisite questions. But if it's completely unrelated, such as the accused alleging that the company is now retaliating against them, what do you do in that circumstance before you let your investigation turn into a marathon? Well, one, you acknowledge it professionally. Say something like, thank you for sharing that. I'm going to note it. I want to stay focused on the current issue, but I'll make sure that it's referred to the appropriate person and processed separately. Document it in your final investigation report that you acknowledged it and referred it also to the appropriate individual. And moving on to the next slide, which, how do we develop a winning investigation strategy? Well, first, we want to set a timeline. As I mentioned earlier, delays create credibility issues, so you can't take forever to run your play. So if you wait weeks to start interviews or months to wrap up, memories fade, documents disappear, and trust really tanks in the process. So let's say, for example, someone reported harassment 3 weeks ago. The company still hasn't started interviews. I mean, what does that say to you all? Now the complainant is venting on social media that nothing's been done. That's not a good look either. And worse, it not only impacts your credibility as an investigator, but also the credibility of the company as well, and employee morale in turn. Determining the order of interviews is another critical pre-investigation preparation step. Who should go first? Because your interview lineup really does matter. Starting with the complainant is usually best because they help you define the scope of your investigation. They give you names to follow up on. And further, a written complaint can only tell you so much, so by talking to the complainant first, you can find out additional information and factual information, I should say, that supports some of the conclusory statements that you may be receiving in a written complaint. And they also will give you names and documentary evidence that you as an investigator should maybe look into, or suggestions in that regard. Then comes the witnesses, but save the accused for last, because at this point, you've gathered as much context and evidence as possible before hearing the accused's side. You also want to consider the right setting for your interviews, in person or virtual, especially in this day and age. In-person interviews can help you build a rapport and observe body language, but virtual interviews, when distance is a factor, or when someone might feel uncomfortable in their own space, or more comfortable, I should say, in their own space, may be more productive for that particular conversation. And I touched on this just now, but just to reiterate, gathering your evidence isn't just speaking with witnesses in the context of an employment-related investigation, also gathering emails, documents, surveillance footage, if that's available on the particular work site of that complainant, policies. This is your scouting report. You don't want to just rely on memory alone, because people misremember things even with the best intentions. Emails can tell a very different story, and a real-time story at that. So moving on to another important point to make when preparing for investigations and how do you conduct your investigations. Your role as the investigator is that of a referee. You're not playing for either team, and so you definitely cannot show favoritism. And this is where we call out bias fouls. There's really no home court advantage allowed. So let's say your top performer in the company has been subject to a complaint from another employee about discrimination or harassment. Just because that individual that is being accused is the company's top performer, that doesn't mean that they get extra points. Same with the beloved leader or one that other employees enjoy working with. You might know the accused personally, or they might be a VP that everybody praises, but you still have to investigate fairly. Staying neutral and leaving personal bias on the bench. I mean, we all carry personal biases, even unconsciously, but the key is recognizing them and not letting them call the shots. So as a practical tip, how do you stop yourself from doing that? Well, ask yourself, am I reacting differently to this person's tone or body language because their personality or communication style? Would I interpret this situation differently if roles were reversed? You want to stick to the facts, not assumptions. This one is a big one. Assumptions are traveling violations in the context of basketball. Easy to make, but they mess up the whole play. So let's say a witness said, he must have been retaliating against me. I complained, and then he stopped talking to me. Well, instead of accepting that at face value, dig deeper. What do I mean by that? Ask questions such as, did he stop talking to you completely? Or did communication just change? Were there any reasons that you could explain? Don't assume motive. You want to prove or disprove it with the evidence. And we'll touch on this later, but just to highlight right now, by not sticking to facts and assumptions, documenting consistently and objectively will ensure fairness, but also clearly show your thought process throughout your investigation. And now I'm going to turn it over to Natalie. How do we manage confidentiality concerns when investigating?
This is a big issue in investigations because you obviously want to get the most information you can, but you also want to preserve confidentiality and fairness to protect the complainant and even possibly the accused and other employees who might be involved. So it's critical to maintain confidentiality, to ensure fairness and protect the integrity of the process and foster trust among the employees. Just as basketball teams keep their game plans confidential to maintain a competitive edge, workplace investigations require discretion. Employers should emphasize to employees, while investigations cannot be entirely confidential, they will strive to limit the information sharing to those with legitimate need to know. Keep it to those who need to know, and remind employees to refrain from gossip, because that's just destructive and it might spread rumors that aren't true and impede the progress of the investigation. Teamwork and trust is really important, and that is critical in the whole confidentiality piece. Maintaining confidentiality during the investigation also builds trust among employees and demonstrates the employer's commitment to fairness and integrity. It's also important in preventing retaliation. Employers during investigations, when they're talking about the confidentiality piece, should reassure employees that retaliation against those who report concerns or participate in investigations is strictly prohibited and will be addressed immediately. Employers also must comply with legal requirements when addressing confidentiality concerns and avoid blanket confidentiality rules, as these may be deemed unlawful or interfere with employees' rights to communicate with government authority, or might be unlawful under the National Labor Relations Act. It's also important to balance the confidentiality part with being transparent. it's important to explain to employees that confidentiality is maintained to protect the integrity, but they can't guarantee absolute confidentiality due to potential legal or regulatory obligations. Making sure relevant witnesses are interviewed and the accused is aware of the allegations are also important when balancing confidentiality interests. It's important to follow a structured approach, and that helps you with this whole confidentiality piece. Conducting interviews in a private location to prevent unauthorized access to information, to prevent people from overhearing is an important part of the process. Sometimes people use 2 investigative personnel, which is a good idea, one to ask the questions and one to take notes to ensure accuracy and professionalism as well. Avoid any types of legal labels like unlawful harassment or discrimination during the interviews. Talk about facts, as Lauren talked about earlier, to prevent bias or tainting the witnesses or their recollections. Document, document, document. We are going to talk a lot more about this today, but that's super important to have accurate and neutral documentation. So it's important to, at the end, to review investigation findings with a focus on confidentiality, limiting discussions of the findings to those with a legitimate need to know. And in doing so, you're going to be considering the credibility of witnesses, the consistency of accounts, and safeguarding information. So it really is a balancing act, but adhering to certain principles, employers can effectively manage confidentiality during investigations while minimizing risks and fostering a positive workplace environment. And I'm going to turn it over to Lauren to talk about conducting the initial interviews.
So every investigation starts with the first key move, the opening tip-off. So just like in a game, the way you start an interview sets the tone for everything that follows. But before you go into the interview, you should do the work on the front end to be prepared. So what does that mean? Creating a written outline to stay focused, organizing your questions by allegations, but also saving space for those unexpected issues that come up. You want to keep it flexible. Starting the actual interview with the witnesses, acknowledge what you are doing and why you are there. Don't assume that the witnesses know why. And this is also your chance to not only build trust, set expectations, but gain a rapport with the witness as well. You want to cover confidentiality, as Natalie just discussed, non-retaliation, but you're really trying to create a safe environment for the witness to feel like they can speak up. You want to avoid asking leading questions. The goal is to gather facts, not steer the narrative. So Mikayla, how do we handle certain witnesses and ask good questions?
Yes, Lauren. Well, investigators need to play both offense and defense when conducting their investigation. So on offense, you need to be prepared to ask follow-up questions. Think of your initial question as a pass, for example, but your follow-up questions are the plays that really lead to scoring critical information. If the first question that you asked didn't yield much, pivot, try another angle, and keep the conversation flowing. Alternatively, on defense, investigators need to anticipate the other team's moves. So it's common to have evasive or vague answers, or when the witness maybe deflects or the accused deflects, and you want to be ready to redirect the conversation or ask clarifying questions. You don't want to let the witness dribble around you, so to speak, with these non-answers or deflections. You want to review the facts, potential inconsistencies beforehand so you can quickly respond and know where they might pivot to try to do that. And just as basketball players watch for pump fakes, investigators need to stay vigilant for inconsistencies or misleading statements during the interviews. You want to keep your eye on the ball by actively listening and comparing the witness's statements to known facts or other statements that you've already seen. So in terms of the questions that we're going to ask, you want to use something called the funnel method. As a funnel, right, it goes from broad to narrow. That's what this method is designed to do. So we start by asking very open-ended questions. Your who, what, when, where, why, explain. The goal at this point is to learn all relevant evidence that the witness has. You want to encourage the witness to talk, to really gain as much information as possible. A good rule of thumb, is the 80-20 rule in terms of you want the witness to be talking 80% of the time, you 20, and it's really important that you're comfortable with silence at this point and you're not attempting to fill in gaps. By being comfortable with the silence, sometimes witnesses are uncomfortable with it and want to fill it with additional facts or details. And, it can also provoke recollection of additional facts. Maybe they didn't initially think of something, but they're thinking harder of it because there's this big silence they're trying to want to fill. So we want to be patient as we exhaust these questions. After we've asked these open-ended questions, then we want to clarify. So for example, where a witness maybe made a generic reference to, their coworker, we want to follow up with, well, who, which coworker, right? What was their name? If the witness says something that, they maybe, quote, know that the accused has done to others, again, a good opportunity to clarify. How do you know? Do you have evidence of that, right? Maybe they have some sort of documentation. And this is a good opportunity to, again, explore whether there's any sort of documents. And if there is, again, whether it's text, emails, voicemails, messages, paper documents, whatever it is, you want to make sure you ask to see it, especially if they bring it up during the interview. So after we've asked our clarifying questions, then we really want to focus on pinning down the witness and getting them to commit so we have final answers. So we want to, again, listen and exhaust these avenues. And once you have additional details, we want to ask very specific questions to get the witness to commit to what they're saying. So for example, you might tell the complainant, okay, you described 2 instances that your coworker touched your shoulder. Were there any other instances that your coworker touched you? No. Again, that's a good way. We've exhausted that funnel. That's a committed, locked-in answer. And again, those are very helpful because it's hard to wiggle out of those later, again, come time for a deposition or in the event of litigation. And at this point, too, at the very end, we want to recap what we've discussed and ask, is there anything else? That gives, again, the opportunity for, the complainant or the witness later to avoid changing their story, since you did ask, was there anything else, that gave them the opportunity to correct it at that time.
So in investigations, listening isn't a passive skill. It's one of your most important moves. You can't run a strong offense if you're not tuned in on the defense, especially in basketball. So let's talk about active listening, because hearing isn't the same as listening. And what do I mean by that? Well, you don't really just want to nod along during witness interviews while waiting to ask your next question, because you may miss clarifying or pinning a witness down in some respects. You also want to give the person the space to talk, even if it's uncomfortable or unexpected. Sometimes, and speaking from experience, the best information comes from just letting the silence sit for a second longer, because the witnesses tend to feel uncomfortable and feel like they need to fill the silence. So if a witness pauses and says, actually, there's something else I should probably tell you, don't jump in, just nod and wait. That extra moment might uncover a key detail or even a new policy violation. So allowing them to fill the silence can be beneficial for the thoroughness and completeness of your investigation. How do you show the witness that you're actively listening? Well, one practical tip is while you've created an outline to be prepared for a witness interview, your outline is not your playbook. It's not a script. If you're focused so much on that next question, you are going to miss just what's happening right in front of you from what the witness is saying. So being ready for completely unexpected issues to arise is key. Flexibility matters, and because when witnesses might bring up new players, different events, or bigger concerns, okay, you weren't expecting it. That's okay though, because you're still the ref. You can adjust, gather the info, and document it properly, but also know when a new issue arises, when that needs to be documented and referred for a separate investigation, as we touched on earlier. Flag it, exhaust it with respect to the related new issue, and then redirect back to where you wanted to drive the conversation from your outline. Hearing is passive. Listening means you're engaged. So picking up not just on words, but tone, the pauses, the hesitations of witnesses. So for example, a witness might say, I mean, it wasn't that bad, but avoids making eye contact with you as the investigator or shifts in their seat. That's a cue, and don't just breeze past it. You can ask appropriate follow-up questions such as, can you tell me a little bit more about what made you say that? Or you hesitated, was there something else on your mind? Words are just part of the story, so watching for changes in voice, posture, or energy, a sudden shift might mean discomfort, fear, or a deeper issue under the surface. All in all, active listening isn't flashy, but it does win games. So stay present and curious. And investigations aren't just about the questions that you ask. Hopefully this doesn't happen to you, but if your investigation report or investigation in general becomes subject to litigation, it also becomes all about the questions you didn't ask either. So when it comes to interviewing the accused employee, and some of the tips that we'll give you with respect to the accused transcend into interviewing the complainant and interviewing other witnesses as well. But when interviewing the accused, this is most often your most sensitive and most scrutinized part of the investigation, because your role is to keep the process fair, focused, and professional. You really have two goals when interviewing the accused. One is information gathering, and the other is giving the accused the fair opportunity to respond to the allegations. Gathering more facts from the accused may give you key context, alternative explanations, or evidence that you haven't just heard of yet. And then giving the accused a fair chance to respond is critical to a defensible harassment claim later on, showing the completeness and thoroughness of the investigation, especially if the allegations are unsubstantiated. Everyone really does deserve a chance to tell their side of the story before conclusions are drawn. But you want to consider how you give notice of the allegations without compromising confidentiality. And this is where you as investigators really do walk a fine line, because the accused needs enough detail to respond meaningfully, but you still need to protect the identities of the witnesses and complainants where possible. So some practical tips. Focus on behavior and not on people. So instead of your direct report said you made a sexist comment, you could try, concerns have been raised about comments you made during a client dinner that were perceived as inappropriate or offensive. You can be specific about what was said or done, but be careful about who said it unless it's absolutely unavoidable. The tone you set in this interview matters. It's not an interrogation, it's a fair part of the process, so be clear, be professional, and be open. How to ask questions of the accused. How do we do that? Well, we apply the same funnel method that Mikayla just walked us through. We start with broad, neutral questions. So we begin the interview with questions that create a calm and non-confrontational environment and that give the employee a space to speak freely. You're not diving straight into the allegations, you're just kind of setting the stage. For example, you may say, well, can you describe your working relationship with the complainant? This helps you understand the context, but it also may reveal workplace dynamics relevant to the issues and allegations that you're investigating. Use open-ended questions to encourage detailed responses. So you want to avoid yes or no questions because you want to give the accused room to tell their version of the events uninterrupted. The more they talk, the more opportunity you have to assess credibility and gather useful facts. So for example, you can say, tell me what happened from your perspective. How did you interpret the interaction? Is there anything else I should be aware of? Avoid leading questions, but still probe. If what they say doesn't match other evidence or witnesses' accounts, your job is to clarify, not argue. So for example, you could say, earlier you mentioned X, but other witnesses described Y. Can you clarify that for me? You said the conversation was brief. Others recalled a longer exchange. Is there more that you'd like to add? Is there any documentation or evidence that supports your version of the events? You can assess credibility without being confrontational. Credibility isn't about just catching somebody in a lie. It is also about evaluating consistency, demeanor, detail, and whether their account lines up with other evidence. So what you are really watching for is, are they consistent throughout the interview? Do they avoid answering your direct questions? Is their recollection overly vague or unusually detailed in selective areas? Does their version match other available evidence that you can check against? Interviewing the accused can also bring unexpected challenges, emotional reactions, and tough dynamics. These interviews require not just good questions, but real emotional intelligence and control. So let's break down some of those common challenges. Your accused is naturally going to deny the conduct. It's common and it will be expected. Your job isn't to argue, but to stay neutral and document their version and test it against the evidence later on. Another pro tip when interviewing the accused, avoid saying like, I understand in a way that sounds like an agreement with the accused. Use like neutral language such as I hear you or thanks for clarifying. Sometimes the accused will demonstrate strong emotional reactions, especially if the person feels blindsided or embarrassed. Stay calm and don't match their tone. You could say and respond. An example of how you could respond in this regard is, I understand that this is upsetting. I want to make sure that you have a full opportunity to respond. We'll go through this step by step. In some situations, the accused conduct will escalate to such a level that you may want to take a break. And you can say, okay, let's pause for a few minutes so we can continue this conversation productively. The accused will also try to blame the complainant, undermine their motives, character, or credibility. You want to listen because it gives you context, but you don't want to let the interview devolve into a personal attack. Your job as the investigator, whether with the accused or with other witnesses, is knowing when to redirect. If they raise retaliation concerns, document them, but don't let them hijack this current investigation. Sometimes the accused might say, I can't respond unless you show me what was said, or who accused me. Be prepared to hold the line in that regard. The accused is not entitled to see all of the evidence mid-interview, especially if it compromises confidentiality. So how you could respond is, at this stage, I'm asking for your perspective on the events based on information I've shared. The process is designed to be fair and thorough, and we'll consider all the facts before making any findings. This gives off or lets the accused know that you're not just jumping to conclusions, that you're going to be testing the evidence, and a report will be issued later on. Wrapping up the interview with the accused is just as important as the way you started it. Effective investigators do this. I do this as outside counsel too when I'm conducting my own fact investigations, but summarizing key points. Before you close, recap the main themes. This allows you to confirm your understanding of what the witness has told you, but also gives the employee a final chance to clarify or correct anything with respect to your understanding. So you could say, well, just to summarize, you shared with me X. Is that accurate? You want to keep your tone neutral, but you also want to leave space for anything you might have missed and invite them to contribute additional names, documents, or other context. This reinforces that procedural fairness aspect of the investigation. Even with the best playbook, investigations don't always go as planned. People get emotional, curveballs show up. This is where you need to be ready to call a timeout and adapt, but still keep the game moving forward. Let's walk through how to handle some of the most common and challenging situations. So for example, what happens if an accused demands for an attorney? Do employees have a right to representation? Well, this isn't a courtroom, it's a workplace investigation. And in most private sector settings, and I can tell you in Florida, employees do not have a right to legal representation during internal investigations. So how you would respond to a Florida employee in Florida would be, okay, this is not a legal proceeding. You are not entitled to legal representation during this interview, but you're welcome to consult with an attorney on your own outside of this process. Now, if you're not in Florida, I definitely recommend you consulting with legal counsel to ensure that you don't need to allow anyone to be present in the room. What if someone refuses to be interviewed? Employees can't always opt out. especially if refusing to participate would be treated as insubordination. So you want to try to understand why they're refusing, reassure them about confidentiality, and if they still refuse, document the refusal. We've talked through some of the witness interview issues with behavior, so I'm just not going to regurgitate much of that, but most important point is just don't match their energy, stay calm, keep your tone neutral, and remind them of their obligation to participate. We've talked about how to interview, but what about note-taking, Mikayla?
Yes, so throughout the interview process, effective note-taking is going to be critical. In finalizing your notes after an interview is kind of like reviewing the game tape, right? You want to make sure everything is clear, complete, and accurate before moving forward. This ensures that you don't miss any key information. When you can, you want to use quotes and avoid using shorthand of what witnesses said. Again, quotes are going to be more persuasive later, and again, harder for a witness to kind of wiggle out of or explain away at a deposition, for example. So your notes should focus on the facts of the interview, and they should avoid personal interpretations or assumptions. Your summary from the interview should be objective and unbiased. There are a couple common problems to watch out for when it comes to note-taking. Again, this might sound simple, but we see these issues often. Not including dates, times, or names, for example. At this point, attention to detail is key, so you should have obtained some of those specifics as you're asking your clarifying question and applying your funnel method during the interview. So we want to just make sure it's memorialized in these notes. Another common issue is inconsistent note-taking or inconsistent retention of notes. So we want to make sure we have consistency there. And another consideration too is miscellaneous notes in the margins of your notes, for example, because these documents may be produced in litigation and it could be in front of a jury at some point. So just be mindful of what you're putting on the paper as well. So we've made it to halftime, and we've discussed preparation's key, the importance of and how to address confidentiality to ensure integrity of the investigation, some common challenges that may arise, some tips about how to conduct your interviews, and the importance of note-taking to ensure documentation. So with that being said, we can move into the second half of the game, which is focusing on analyzing the information that we have gathered. So what data are we analyzing? Well, it was what was obtained during the investigation, right? So your sources of evidence are going to include, again, any sort of documentation that might have been provided, whether it's by the complainant, the accused, or other witnesses, emails, the policies that you've identified previously that are applicable, witness statements, surveillance footage, texts, personal messages, all of that. And I want to highlight surveillance footage too, where applicable or appropriate, because sometimes that can be forgotten about. And we did talk about timeliness of investigations, and we just want to be mindful because sometimes footage might not be retained for as long of periods of time as other evidence, like an email, obviously, for example. So just be mindful of that too. But we want to remember to stick to the facts that were obtained from the evidence when evaluating whether the complaint was substantiated or not. So what should you be on the lookout for? Well, as the investigator and you're evaluating this evidence, you need to be able to spot the fouls. If a witness is changing their story or there's conflicting information, that could be a sign to pause and reassess. You want to compare the witness statements that the notes from your interviews in the witness's accounts to the evidence, again, any sort of documentary evidence that you might have received, and with other witnesses' accounts to try to verify accuracy and identify inconsistencies. So at this point, credibility is going to be key to determining which witness provides the most reliable account. So we want to consider factors such as consistency, corroboration, memory, perception, and truthfulness. So Natalie, I want to turn it over to you. Can you tell us what else investigators should keep in mind?
Absolutely. Managing legal and compliance risks during the course of the investigation is critical. And it's important to not rush the process, because just as rushing plays in basketball games can lead to turnovers, rushing workplace investigations can result in errors, incomplete findings, and misevidence. Take time to plan, as we've talked about before, identify key witness, safeguard evidence, and ensure compliance with legal requirements. And also, to employees, a rushed investigation may appear biased or unfair, which would increase the risks of legal harm. Now, I just said, don't rush the process. Also, try to avoid delay. That's very important. There's no set time frame, and a couple of questions have come in the chat about time frame to conduct investigation. There's not a set time frame, but it's important to promptly react. And even if you might not be able to start the investigation, touch base with the complainant, say, your complaint is very important to us. We are working on investigating it, and maybe check in with them if it's going to be delayed because of staffing issues or people being on vacation, et cetera. Just like Mikayla just talked about, delays can lead to deterioration of evidence, loss of witness credibility, and increased liability risks. So it's very important to start it as quickly as possible. It also reassures employees that their concerns are taken seriously, and it helps prevent the issues from escalating. Retaliation and anti-retaliation policies, and emphasizing those to those who participate in the investigation, including the complainant and the accused, is very, very important. It's important to emphasize to folks you're talking to that retaliation is not tolerated. It's also important to monitor the workplace after the investigation concludes to ensure retaliation is not occurring. It's very important to follow company policy. Standardized investigation guidelines, processes, and templates help promote objectivity, having kind of a standard procedure to follow. Obviously, each investigation is going to vary a little bit depending on the circumstances, but consult legal counsel to ensure compliance with applicable laws, such as preserving attorney-client privilege, avoiding blanket confidentiality rules, which might violate the National Labor Relations Act, and document all steps of the investigation carefully. There have been a lot of questions about confidentiality and balancing that with the NLRA's requirements. You can't limit employees' ability to engage in protected concerted activity. Those questions are complex and fact-specific. You really do have to consider the legitimate business interest in maintaining the confidentiality of the investigation, but balancing that with employees' protected rights. So keep that in mind as you're going through the investigation. Consult legal counsel, and we can get to those questions offline, because there have been a lot of them coming in about that. All right, avoiding pitfalls is important, but also you have assistance. As a supervisor who might get a complaint of discrimination, harassment, or unfair treatment, you have an HR team and legal teams that you should enlist and collaborate with to help these investigations start and conclude smoothly. First, it's important to ensure supervisors and managers know when to loop in HR. Sometimes they don't know. And it's important that they know HR is the first line of defense. We want to make sure that HR is well-versed in policies and procedures. There's neutrality and objectivity. Supervisors should know when to escalate it to HR. And also, it's important for HR to know when to involve legal counsel, internal or external. Legal counsel should be involved usually when the investigation is potential legal claims, regulatory violations, high stakes issues. And then there's a lot of issues surrounding preserving attorney-client privilege and involving legal counsel early to help preserve this privilege, particularly when the investigation is conducted at the direction of counsel. You want to ensure communications are clearly labeled as privileged and confidential to strengthen the argument for privilege, and be mindful that privilege may need to be waived if the employer asserts a good faith defense in litigation. And I am going to turn it over to Lauren to talk about drafting investigation findings, because you've done the investigation and the documentation is critical. Lauren?
Yeah, so we want to be clear, concise, and fact-based. And I think just to kind of speed this along, because we've been saying a lot of the stuff throughout this presentation, one of the points I wanted to really highlight is that your investigation report needs to make a record of your reasoning and the steps that you took. So a good report doesn't just give a conclusion, it shows how you got there. That includes who you interviewed, what you interviewed, how you weighed credibility, and what facts tipped the scale. So for example, the respondent's account was inconsistent with contemporaneous emails and was not corroborated by any other witness. Two independent witnesses provided similar accounts, supporting the complainant's version of events. There's absolutely no question to how you weighed the credibility and why you weighed the credibility, such that the integrity of your investigation will be upheld if forever, for any reason, you were ever to be sitting in a deposition chair. So, Mikayla, how do we present findings?
Yes. So when communicating outcomes, it's important to consider that you have different audiences, right? So your approach needs to be, strategic and tailored for that. So with respect to the complainant, for example, one common mistake is after you conduct the investigation, either not following up with them or telling them more than they need to know. So it's a good idea to limit, your conversation to that the investigation has happened, it's been concluded, and whether the complaint was substantiated or unsubstantiated. But you should not go into the details about what specific action is being taken against the accused, for example, if substantiated. With respect to the accused, we want to specifically tell them, obviously, what specific action is going to be taken if the conduct was substantiated. And it's critical here to ensure that if corrective action is taken, that it's consistent with past practices for discipline of the same type of infractions. So on that note, if corrective action is taken, make sure it's documented, and I want to emphasize, make sure it's documented well. So we're going to go ahead and move to overtime in the last couple minutes here to discuss some special considerations and emerging trends. So when it comes to digital evidence, right, we've talked about it, but I just want to highlight here that, evidence can also be manipulated, right? We've seen faked text messages. So when you're reviewing the documents that you're provided, just review them with a very critical eye. But I'm going to go ahead and pass it over to Lauren to talk about some additional trends that we're seeing too.
Thanks, Mikayla. Yeah, so especially with AI in this day and age and as it's emerging in the future of the workplace, it's definitely going to be used with respect to workplace investigations moving forward and as we train and become more utilized with AI tools. But what can it do for you? And what can't it do for you? Well, it helps you analyze data, sort through large volumes of emails and documents, especially when you're reviewing hundreds of thousands of emails or files or chat logs. AI can help you detect quickly relevant keywords, timelines, and communication patterns. It can flag emails with concerning language, detect shifts in tone, or surface threads that include multiple people involved in the incident. It dramatically will speed up the early phases of your evidence collection. AI can detect patterns, but it doesn't replace human judgment, and I think that's critical here. AI can spot red flags, like repeated complaints about the same manager or spikes in the workplace conflict following policy changes, but it can't read nuance, assess credibility, or make policy determinations. That still firmly lies in the hands of our human investigators. So you can use AI as a tool, but not as a decision maker. You still need trained investigators to interpret data in context, connect the dots, and assess the human side of behavior in the workplace. But also be aware of bias in algorithms, privacy risks, and legal implications. AI is only as objective as the data that it is trained on. And if the input data is biased, which often it is, the output is also going to be biased and reinforce those same biases, especially in areas like tone analysis, sentiment detection, or employee monitoring. So the takeaway is organizations really do need to make sure that they have clear policies regarding AI, human oversight in their investigations, and legal review when using AI in any investigations, if at all. AI, while it can make us move faster and spot patterns we might miss, it can't replace our judgment, empathy, or ethics. The future of fact-finding is human plus AI, not human versus AI.
Okay, to wrap up, we're going to wrap up pretty soon. We have a few seconds left. Takeaways: prevention is the best defense. Train managers and employees before the problems arise. Encourage early reporting, and keep your playbook updated by regular policy review, making sure that you consider the results of other investigations to determine whether you need to modify or consider policy changes. We are, preparation is key, stay neutral. Those are good takeaways. Follow the rules and document. We appreciate your time today. I know we're right at the hour mark, and so I'm going to turn it over to Stephanie Zielinski. Again, please feel free to contact Mikayla or Lauren or me offline via email. We appreciate you attending. You've got great questions, so hopefully we're going to be able to answer those offline. Thank you so much.
Natalie, Lauren, and Mikayla, thank you all very much for these great basketball puns and even better insights on effective and lawful workplace investigations. Before we conclude today's event, I'd like to offer another opportunity for today's attendees to register for a demo of the ComplianceHR Navigator Suite. With all of the possible pitfalls of employment law compliance, it's critical that you don't leave your compliance strategy up to chance. Our suite of solutions is designed to support employers like you while saving your organization time and money. Again, thank you all very much for taking the time out of your busy schedules to attend today's webinar. We hope that you enjoyed the content and have a great rest of your afternoon.